Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. The California Appellate Law Podcast is a resource for trial and appellate attorneys. Both Jeff and I are appellate specialists, but we split our time about evenly between trial and appellate courts. And in each episode, we try to provide some news and perspectives that our trial attorney and appellate attorney audience can use in their practices.
And a quick announcement, our podcast is sponsored by the folks at CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse the service. And listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
All right, Jeff, we're nearing the end of 2022. We thought we would compare notes on what cases and legal news stories struck us as maybe the most significant of the year. Most significant, that is, to generalist trial and appellate attorneys such as ourselves and our audience. Our criteria does not include significant substantive developments in the law. That's beyond our pay grade. So we're looking back on 2022 now with the hindsight of a statewide court reporter shortage, the changing of the guard in the top judicial seat in the state, which we discussed with David Ettinger in episode 53, and a number of vacancies waiting to be filled on the Superior Court and the appellate court benches. That was covered in episode 38 about delays in the 3rd District. And we're now watching new judges and justices begin to decide cases. This reminds us of the importance of the continuity in legal training, and that brings us to the legal news in 2022 about law schools beginning to drop standardized testing and ranking criteria. But we wanted to talk about some of the interesting cases that we covered on this podcast and beyond. I thought we kind of bookend Jeff, did you want to break in here?
Well, I was just going to say, for people who may not have heard all our episodes from the beginning, I know some people have only recently started listening. A lot of these cases we're about to discuss will reference earlier episodes and be a nice index if you want to go back and catch any cases you missed.
Yeah, that's right. So we will reference what episode we discussed the cases in. So log into calpodcast.com and you can reference the back catalog there. I thought we'd start with what my vote is for the most important case for money litigators anyway. Those of us business litigators who are fighting over money, that business litigators need to know about the civil theft remedies under Penal Code Section 496. And Jeff, there had been some cases going back and forth on whether you can bring civil actions for under that penal code section. There are some cases that said yes and some cases that said no. And we had waited in the Supreme Court for a ruling on that. And we got it this year in Siry Investment LP versus, let's see if I can pronounce this name again, Farkhondehpour. That was a July 2022 case out of the Supreme Court that held that you may still bring civil fraud actions under Penal Code Section 496. The court does provide some limits to it because they do not want you turning every garden variety business tort case into a Penal Code 496 case, but it does carry the benefit of treble damages plus attorney's fees. So if it does fit in your case, business litigators need to have the Siry Investment case in their back pocket. All right, let's go to some other top cases of 2022. Here's a list that I started. Some of my picks, Jeff, but you jump in if some of these cases are among your favorites as well. I'll start with a briefing tip. This is out of Singman versus imdb.com. This stands for the proposition that if you fail to bookmark, if you fail to cite to legal citations or legal propositions in your brief, those legal propositions will be ignored. I believe that's only going to apply to appellants' legal propositions. Respondents' legal propositions usually are given the benefit of the doubt or at least the benefit of some additional research by the court's research attorneys. But if you're the appellant and you don't cite to a legal proposition, it will be ignored. We discussed this in episode 23.
And a secondary point from this case, if you're thinking about representing yourself in a case you've lost, take a look at this case. The improper appellant didn't do so well.
Right. All right, another case on dismissed appeals. We covered Alexi and Ani LLC versus Warren in episode 23, in which the case allowed an attorney allowing an attorney sanctions appeal to proceed even though the attorney was not listed on the notice of appeal. I thought this was interesting, Jeff, because I had previously gotten appeals dismissed on this very ground. This decision was unpublished, but it is instructive that courts may be looking to excuse appellants who fail to include the proper attorney appellant in the notice of appeal. So check out episode 23 for more on Alexi and Ani versus Warren. A couple appeals concerning court reporters. Weishuttle versus Vo involved a dissent over whether a court reporter is really needed at oral argument on a motion to compel arbitration. The majority said it was a question of law, so the lack of a reporter's transcript was not fatal to the appeal. But the dissent said that in close questions like this, a court should assume that something might have been said on the record that would have supported affirmance. So that's something to be aware of. If you're in doubt whether you should bring a court reporter to a hearing, you probably should bring the court reporter. And again, noting, as we said at the top of the episode, there is a court reporter shortage. So make sure you're sending lavish gift baskets to your court reporter vendors this holiday season. We covered Weishuttle in episode 23. And we also covered RM versus JJ on the question of if you don't have a reporter's transcript, Jeff, there are still provisions in the rules that allow for other forms of creating an oral record, like the settled statement. But RM versus JJ teaches don't even bother. You might not even bother with the settled statement because the trial court has wide latitude of what not to include, and I've yet to see any limits to this latitude. I put an article on this, so we'll put that in the show notes. We discussed RM versus JJ in episode 40. We discussed a couple of criminal cases. One of them had to do with, let's see, this was at United States versus Olson. The question was, can the Sixth Amendment right to speedy trial be indefinitely postponed due to COVID? The answer was yes, if the defendant is not incarcerated. That was a Ninth Circuit decision. We covered that in episode 25. On a related note, we also covered the right to a jury trial. Can the statutory right to a timely conservatorship jury trial be waived? The answer is yes, even if the judge kind of pushes you around. So stiffen up that spine. We discussed conservatorship of Joanne R. in episode 25. In that case, the court affirmed the waiver of the right to a speedy jury trial that challenged a 12-month conservatorship, even though the trial court would not provide a jury until the 9th month.
Yeah. We also discussed that a jury trial can't be waived merely for failing to comply with local rules. I know down in Orange County, where you and I have some matters pending, they have rules regarding assembling a binder and meeting and conferring with opposing counsel regarding joint documents. Non-compliance with these local rules cannot form the basis of a finding of a jury waiver. That was the Amato v. Downs case from May of 2022.
Right, and let's see. Let's keep on a similar vein here. Right to there's cases dealing with the right to in-person appearances. People versus Whitmore held that there was no right to an in-person appearance. It held that limiting a defendant to a virtual appearance, even though it was legally improper, created no harm. So it basically, the appellant was not able to get over the prejudicial error hurdle, it sounds like. Yep, we discussed People versus Whitmore in episode 34. And then Jeff, you want to talk about the Zoom trials? Are Zoom trials?
They are not. As of the recording of this podcast in December of 2022, Zoom trials are no substitute for real trials, not unless the California legislature says so before July 1st, 2023. Tim had a great write-up of the Rice v. Superior Court case, and we discussed that in episode 55.
Yeah, that is a space to watch in the first part of 2023, whether the California legislature extends the virtual trial statute and allows virtual trials to continue in place of live trials. But after July 1st, 2023, we have to go back to the presumption of the old normal, not the new normal.
Right. And we also had Eric Kingsley on the podcast in episode 49 discussing the U.S. Supreme Court's holding in Viking River Cruises versus Moriana. And he talked about the future of PAGA claims. And I think I might need to go back and listen to that 2 or 3 times to really understand what he was saying. But if your practice involves PAGA claims, it's a must listen to episode.
I have to say that subject is very dense going, but I thought Eric did a great job in laying it all out. Another important arbitration related opinion was Quach versus California Commerce Club, I think it is. That held that the right to arbitrate is not waived even after happily litigating for 13 months. The court found that the only prejudice shown was litigation costs, and that is not enough to show prejudice. So the right to arbitration was held not waived, and rehearing was granted, and the opinion was partially published after a publication request from yours truly. All right, Jeff, there were a few anti-SLAPP cases that we covered. This being your bailiwick, I'm going to let you have first crack. Which one you thought the most important? Choose wisely.
Well, we had predicted earlier in the year that anti-SLAPP denials may not be appealable for much longer in the Ninth Circuit based on some dissents. But I have to say, it has not come to fruition. I haven't actually seen the Ninth Circuit taking any moves to take on cases and re-examine this issue. And so for the time being, anti-SLAPP denials are appealable, but we covered that in episode 38.
Yeah, but they're appealable as collateral orders, so they go about it a different way because they don't have the Code of Civil Procedure 425.16 that or 904.1 that makes them appealable by statute. So they're appealable under the collateral order doctrine, and Judge Bress disagreed that they should be treated as collateral orders. But yeah, like you said, we haven't seen any more movement on that space.
And then you actually got published in a legitimate publication for the proposition that anti-SLAPP fee awards might be stayed on appeal. I, of course, vigorously disagree with that proposition, but congrats on the write-up.
I await your sternly worded letter to the editor, Jeff.
Consider this podcast that letter.
Yeah, we've revisited that issue. That's an important issue to keep in mind. It's one of those where there are 2 published cases on either side of the coin. So whatever position you find yourself in, there is a published decision to cite, and under auto equity sales, you may the trial court may select either one that it feels more persuasive. So the Dowling versus Zimmerman is the case that Jeff likes to cite for the proposition that SLAPP fee awards are special. They're super special, and they're not stayed on appeal. And Quiles versus Parent is the 4th District more recent case, better reasoned case that holds that they are costs like any other costs, and they are automatically stayed on appeal. But either way you find yourself, you have a published decision to cite. We discussed that dichotomy in episode 41.
Yep. And we discussed in episode 47 that spending money on litigation is not protected activity within the meaning of the anti-SLAPP law if the case is really simply about the misappropriation of the money. And that was the Manlin v. Milner case from August 2022 that initially was unpublished, and then Tim put in a publication request and got it published.
That you co-signed?
I did. Yeah, I'm partly to blame. And we also covered in episode 47 that opposing an anti-SLAPP motion outside the 60-day window is possible, but this case, Reyes v. Escobar laid out the factors that have to be weighed by a court when you want to go outside that 60-day window. Let's shift gears and talk about MSJs. Anytime a defendant is moving for summary judgment, they will frequently rely on the Union Bank case that discusses factually devoid discovery responses to meet their initial burden and shift the burden to the plaintiff. In a companion case now, Field v. U.S. Bank, evasive discovery responses that are factual yet evasive can similarly be used to shift the burden in an MSJ, and that we covered that in episode 42.
Yeah, I think those are always great procedural tips to be aware of for MSJs. Another one on MSJ appeals. I know a lot of practitioners were watching the space after the Reed versus Google decision of the Supreme Court, I think that was back in 2010, that had cracked the door open and suggested that evidentiary rulings in the MSJ context may be reviewed for on de novo basis rather than the more deferential abuse of discretion. But most district courts of appeal had said, nah, we're going to continue reviewing them for abuse of discretion. And the 4th District, 3rd Division joined that chorus and said, no, we're going to, there were just a ream of evidentiary objections lodged by the opposing party, and court decided we don't want to have to read and review all that. We're going to review it we're going to assume that the court didn't abuse its discretion, and that decision is now published as well as a result of yours truly's request for publication. On the topic of expert witnesses, we covered Durham Cup Klein versus Zimmer. This was one of the many lawsuits filed by hip replacement patients against the maker of the Durham Cup. The case is Klein versus Zimmer. This is a case out of May 2022 out of the 2nd District. The court held that the trial court had committed structural error when it improperly excluded Zimmer's expert to rebut the plaintiff's expert. This was surprising because normally trial court rulings on evidence are reviewed for abuse of discretion, and errors are only reversed if the appellant shows they affected the result. But the exclusion of a rebuttal expert here resulted in automatic dismissal. This was discussed in episode 38. All right, let's talk about topics that make your head hurt. Jeff, mootness, doctrine of mootness. I hate the doctrine of mootness because it seems to me so unevenly applied. If you're the respondent, you can't count on the doctrine of mootness to reliably win a motion to dismiss, because mootness is a discretionary doctrine. But if you're counsel for the appellant, you have to lie awake at night imagining the ways that an ongoing litigation might moot your appeal and get it dismissed.
And if you're an appellate justice that wants to avoid deciding an issue on the merits, you can certainly use the mootness doctrine when suitable.
It is, it is just for any purpose that can be convenient to the court. It can be applied or disregarded almost at will. So we covered artwork studio and classroom versus Leonian. This was a case in which the underlying lawsuit was not stayed. It resulted in the appeal becoming moot. We talked about the artwork studio case in episode 31. We covered another case that asked the question, can you dismiss your lawsuit while it's on appeal? The answer is no, under Curtin Maritime Corp versus Pacific Dredge and Construction. We covered that on episode 31. Now, Jeff, I'll let you cover Brock v. Newsom, because I know you have an update on that case as well.
Well, yeah, we each came up with our separate lists of top cases of the year, and this is one of the ones that's on my list, Brock v. Newsom. This was a lawsuit that was filed by a school board member in my neighborhood, Palos Verdes, and it attacked Governor Newsom's measures in response to COVID-19. The district court did something really unusual. It granted summary judgment sua sponte, dismissed the case. The Ninth Circuit affirmed, but mostly affirmed, I think, on the grounds of mootness, saying this really wasn't an open issue anymore, given the schools reopened by the time the Ninth Circuit heard it. The two updates on the cases. First, Matthew Brack has sought by the United States Supreme Court on whether it's truly moot or should be heard on its merits. And California filed we're not going to really respond to this petition for certiorari response. And the Supreme Court said, California, we want to hear from you. And so there's now a December 28th deadline for California to respond to the petition for certiorari. That's one update. And then second update is Matthew Brack is now a former member of the PV school board in losing his bid for re-election.
Okay, great update. All right, and here's the final case in the subject of mootness. Here's the prompt, Jeff. Have you ever had an appeal dismissed? It hurts, of course. It always hurts when you have an appeal dismissed, but there may be a silver lining. If the underlying if your appeal is dismissed, the underlying judgment may no longer have any preclusive value. And that's what happened in the published decision in Parkford Owners for a Better Community versus Windeshausen. I believe that the appeal in that case was dismissed on mootness grounds, and the outcome was that the judgment the judgment underlying the appeal that had been dismissed as moot was no longer had any preclusive value. And I thought, what kind of mischief? There would be no end to the kind of mischief that you could wreak with that. You just take up the appeal and then have it dismissed for failing to designate the record timely or for any other reasons, and then you sap the preclusive value. I just thought that was an enormously surprising result. And
every lawyer practicing CEQA needs to read that case. It's very counterintuitive.
Yeah, so we discussed Parkford Owners versus Windeshausen in episode 52. All right, we covered some cases dealing with judgment collection. I think this was one of the more understudied areas of the law, Jeff. And so we brought on a specialist in episode 46, Joseph Chora, and we talked about all sorts of sneaky tips and traps in the judgment collection area.
Yeah, if you ever wanted to know when and how and under what circumstances you can seize a debtor's pet in response to collecting on a judgment, that episode answers that question.
That's right. Okay, we covered Sylvester versus Neparko in June of 22. That was a non-published decision, but the case involved a plaintiff and defendant who had agreed to use a general verdict form in exchange for a stipulation to limit judgment enforcement to insurance and indemnity. And I picked that case. I just was really surprised that you could do that. You could limit your rights to judgment enforcement in exchange for horse trading on verdict forms. We discussed the Sylvester versus Neparko case in episode 46. And then more recently, we discussed WV23 Jumpstart versus Minarsik. That was a case that held that personal jurisdiction is unnecessary to issue a judgment on an out-of-state judgment. So basically, if the case involved a Nevada judgment against a series of judgment debtors, the plaintiff decided, I'm going to domesticate the judgment in California, even though it had no contacts with any of the defendants. And then when the Nevada judgment expired, the plaintiff went and re-domesticated the domesticated California judgment back to the original form in Nevada. And at that point, the debtor was jumping up and down and saying, "What are you doing? That this is now based on a judgment under which I had no personal, no minimum contacts. There's no personal jurisdiction." The court said, "Nah, that's okay." And so my two upshots from this case that now I've been pushing on anyone who will listen is that if you have a judgment, then you might as well go ahead and domesticate it in a stay fresh jurisdiction like Delaware, in which judgments never expire. Go ahead and park your judgment in Delaware. That way, in case you forget to renew your judgment, it will stay fresh in Delaware. And then also, why not park it in a high yield jurisdiction like Rhode Island or Massachusetts, which gives 12% post-judgment interest? Hey, why not? Let it rack up extra interest while you're waiting to find assets. And then once you find them, domesticate it wherever the assets are, and then you're off to the races.
Right.
So that was the WV23 Jumpstart case. We discussed that in episode 62. All right, let's talk about sanctions. As to trial court sanctions, we covered a case. Everyone knows about the 21-day safe harbor. If you want to seek sanctions under CCP 128.5 or 128.7, you have to file a nice letter and attach a copy of the motion that you're planning to file, and then wait 21 days. This plaintiff or this moving party waited and filed on the 21st day. But filing on the 21st day is not waiting 21 days. It's only waiting 20 days. And so jurisdictionally, it had to be invalid. So that was the Transcon Financial versus Reed and Hellyer case. We discussed that in episode 58. And even though one of my asides on that case is the court didn't get to the prejudicial error prong, didn't say why the 1 day would have mattered.
Right.
All right. You want to discuss these one of these cases on appellate sanctions, Jeff? I think you had covered one of these for us before.
Yeah, so there's the Schreiber versus JP Morgan Chase Bank case from July 2022, in which the court advised an attorney to think twice about clogging the docket. And we also covered the Pop Top Corp versus Rakuten Kobo Inc. case from July 14th. Those are both covered in episode 45, in which the dissent suggests the majority had imposed over 100 grand in sanctions merely for filing a weak case. As the dissent warned, the right of appellate review applies to even weak cases. Interesting reading for anybody who's seeking or opposing sanctions.
Yeah, I haven't watched this space for a long enough period of time, Jeff, but maybe you have. Did it seem to you that there were more appellate sanctions awarded in 2022 than in prior years?
Certainly, I noticed them more. Yeah, I see them more, and also in my practice, I'm seeing them more and more.
Yeah, I thought this was this case, the Pop Top Corp versus Rakuten, was presented an interesting both sides of the coin. It showed a majority who was kind of fed up with these with what it deemed to be frivolous or meritless appeals, and then arguing for the other side of the equation, the dissent, saying, look, I'll grant you it was a weak case, but weak is not the same as frivolous. $107,000 in sanctions for just a case that you find to be to lack merit or to be weak is it chills due process rights, to the right to appeal. We talk about motions for reconsideration. We've talked about the fact that motions for reconsideration filed after a judgment are a moot point, because once a judgment is filed, the matter is final, and your remedy now is an appeal or one of the other statutory remedies, like a new trial motion or motion to vacate. There's no the trial court no longer has jurisdiction to reconsider a judgment under its own inherent authority, or even 1008. But we also talked about a couple of cases involving I remember the cases we talked about, whether okay, so compare these two cases: Banks versus Masterakos. This was a second district case that awarded $960 in sanctions against a plaintiff for bringing a frivolous motion for reconsideration. Basically, there was no new facts or law, so what are you doing? This is just wasting our time. You can't just reconsider an opinion, just a decision, just because you don't like it. But compare that with Brown, Winfield, and Canzaroni versus Superior Court. This was a 2010 case, but it had held that, quote, it should not matter whether the judge had an unprovoked flash of understanding in the middle of the night or acts in response to a party's suggestion, which suggests that even if you are filing a motion for reconsideration, not because of any new facts or law, just because you think that the judge, maybe didn't weigh the factors correctly, should have granted my motion. And even if it's beyond the 10-day period, then there's no reason that the judge can't act on it in its inherent discretion. So those are two cases to bookmark on either side of the equation, that yes, the judge can consider your motion for reconsideration and even act on it, or the judge could sanction you for it.
Right.
Let's move on to statements of decision. We talked about a couple of cases dealing with statements of decision. This is a very important appellate procedure point. If you ever talk to an appellate attorney, get ready for a long discussion on statements of decision. Failure to request a statement of decision changed the outcome of the appeal in Marriage of Berger. We discussed this in episode 52. So even though the trial judge had issued a written decision, the appellant lost her appeal because she failed to request a statement of decision. Statement of decision is not just the same thing as the judge giving its thoughts on the record, even writing a minute order containing those thoughts. A statement of decision is a different statutory animal. And even though the appellant had a statutory right to findings, she still had to formally request a statement of decision. But I noted that this reasoning appeared to contradict a similar circumstance in another 2022 published opinion in Abdelkader versus Abraham. When we discussed that in episode 52, where there was a statutory right to findings in a custody circumstance, and just because you fail to request a statement of decision does not abrogate your your independently existing statutory right to findings. So it's important. I think either way you find yourself, it doesn't hurt to request that statement of decision.
Right. No appeal was ever lost for requesting a statement of decision too many times.
That's right.
And hey, Tim, have you started adding a under penalty of perjury signature line to all the memo of costs you've been filing in your trial victories?
That's my suggestion after this this case that we discussed, Arabian versus Triangle Truck Center. I haven't filed one yet, but what's your plan, Jeff? Are you going to start adding them?
If I remember, sure. Yeah, you bet.
Yeah.
No memorandum of cost was ever rejected for the inclusion of perjury language on it.
Yeah, we covered this in episode 52. There was a dissenting justice notes that there's a fatal error in the Judicial Council cost memorandum form. So the rules of court, the dissenting justice noted, require that a cost memorandum be signed under penalty of perjury, and the Judicial Council form for appellate costs does contain that penalty of perjury statement, but it's not contained in the what is it, MC? I forget, ONO or whatever it is, the memo of cost form for costs after trial. It's not contained there, so there was a big colloquy in that decision about whether the prevailing party was entitled to costs, because there was no, it was not supported by an evidentiary showing.
No.
Jeff, you want to cover the Trujillo case?
Sure. That was the case with the odd result where a 998 offer, which by statute is open open for 30 days. The appellate court held it was cut off when a trial court orally announced ruling on a summary judgment motion within those 30 days. So the PI lawyer here had lost a summary judgment motion, at least verbally on the record, had run back to his office, sent an email saying, I accept the 998 offer. That acceptance was held to be invalid. A very curious result. And I just checked before we recorded this episode, and I noticed the losing party in that case, although they filed an unsuccessful petition for a hearing, they have not filed a petition for review, and the time to do so has expired. It looks like Trujillo is a final opinion.
Yeah, and the other interesting thing about Trujillo is that it takes the complete opposite tack as the federal courts on this question under its substantively identical rule under FRCP 68, that it's to the offer remains open for, I believe it's 21 days under Rule 68, even if there's been a ruling on a summary judgment motion that would seemingly render the offer futile or moot or otherwise stupid, it's still open under that statute. But the California courts did not choose to go that route.
There's no reason that Trujillo couldn't be applied in the context of demurs or slaps or other dispositive motions. When there's a 998 offer made and within the 30 days, a dispositive motion is verbally granted. Under Trujillo, those 998 offers, the ability to accept them could be cut off.
Yeah, that's right. And one of the other oddities that we pointed out is that the rule under Trujillo, that specific holding, is that the 998 offer is deemed to expire when the judge issues a oral ruling on the MSJ. But what happens when the judge issues a tentative ruling on an MSJ? Then you could still accept the offer.
Yeah. All right, Tim, now buckle up here. Here is my list that I came up with the 7 biggest either stories or cases, not necessarily covered on our podcast, the 7 biggest stories that I think impact California lawyers either in the past year or the year to come. Here we go. With apologies to David Letterman. Number 7, can a pre-litigation demand cross the line into extortion and then fail to qualify for protection under Civil Code Section 47's litigation privilege? The answer is yes, if the attorney threatens to disclose the allegations to blow up the defendant's potential merger. We covered this in episode 25. It's the case of Falcon Brands, Inc. versus Masavi and Lee. The great quote from that case is, lawyers argue for a living. Some do more than argue. They lace their settlement demands with threats. When does such activity cross the line and become professional misconduct? That is the fundamental question presented in this case. It's a great case for anyone who practices anti-SLAPP law and needs to know the line for settlement demands.
Right.
Case number 6 is, we covered this already, Brack v. Newsom. We gave that update. Case number 5, or issue number 5, the biggest story of the year, is the court reporter shortage. They just recently announced they're not going to have them in LA for family law, probate, and restraining order courts. It's a growing problem regarding the appellate record. We're going to see more and more attempts to get settled statements. And I think the end of this story, perhaps as early as next year, is we're going to see legislation allowing recordings to be used in lieu of court reporters, and ultimately AI-generated transcripts, at least as a starting point for a transcript. I think that's the direction we're headed.
Yeah, that could be. What do you think about this idea of? Do you think that a lot of court reporters are getting snaffled up by private arbitration?
I don't think so, because there's no data to suggest there's an increase in the combined demand for court reporters in terms of litigation and arbitration. The real problem is nobody wants to be a court reporter anymore. That's the problem. And throwing money at court reporters isn't solving the problem. The real problem is we've got technology that could fix the demand, and just need the legislature to sign off on it. That's my 2 cents.
What is that profession is just too remunerative and too flexible?
The real issue is going to be next year whether or not the reporters lobby will do anything to block legislative changes in Sacramento. That'll be interesting to see.
Yeah.
All right. Number 4 on Jeff's list of top issues of the year is the fall of Tom Girardi. Now, my law school, Loyola Law School, they used to have a mock trial courtroom, an entire building named after Tom Girardi. And when I was in law school, I had friends that worked at that firm. So huge, prestigious firm. And I was at the school this year to give an anti-SLAPP MCLE lecture earlier this year, and the building had been completely renamed, stripped of his name.
Oh.
And although it was late 2020 and early 2021 when news broke about Girardi and his settlement funds being diverted, really the fallout didn't really start hitting the fan until this year. And just recently they discovered that the former CFO for the firm had a side fraud going on, having nothing to do with Girardi, where the CFO was taking $10 million out of the firm and buying homes in the Bahamas. But the most significant part of the story isn't the misdeeds about Tom Girardi or his CFO, but how the state bar looked away and disregarded numerous state bar complaints about him. The state bar had received 205 complaints, and 120 of those complaints involved client trust account matters. And about half of those complaints came out even before the public reports about misdeeds about Girardi came to light. And the LA Times recently reported that at the same time that Tom Girardi was not being prosecuted, African-American male attorneys had a higher rate of prosecution at the state bar than white male attorneys. Interesting. And as a result of this misconduct by Girardi, the state bar has enacted new enhanced oversight and reporting requirements for California lawyers regarding trust accounts. Tim, I think every January now we have to sign new statements regarding our firm's trust account reporting and our ability and compliance with the rules. I think the oversight of trust accounts is really going to be tightened in the years to come.
Well, I hate to see the reputation of the state bar being sullied by this disparate impact. I wonder, what are they going to do in response to that?
Yeah, well, I'm sure there'll be committees and commissions and reports. I think for years we'll be feeling this for years to come.
Yeah.
All right. Story number 3 on my list: National Pork Producers Council versus Ross. Now, Tim, it's not too often that state court appellate attorneys like you and me get an opportunity to discuss the Dormant Commerce Clause doctrine. I don't think those words have come out of my mouth since the 1990s when I was in law school. The Dormant Commerce Clause is a refresher of the legal doctrine that says states should not be able to pass laws that burden interstate commerce or discriminate against out-of-state businesses in subject matters where Congress has the power to regulate commerce. In a National Pork Producers Council case, the U.S. Supreme Court's been asked to weigh in on California Proposition 12, which is an initiative that our state passed in 2018 to impose conditions on how pigs and other animals are housed and cared for before they're slaughtered and sold in California for food. The law basically prohibits the sale of pork in California if the pig was housed in a small cage. The case was argued in October of this year, and no opinions come out yet. The repercussions of this case will be felt beyond food products. It will impact whether one state can pass laws that constrain the economics and policies of other states. One example that came up during oral argument over this case in the Supreme Court is that if Proposition 12 were allowed to stand, California could pass a law prohibiting the sale of pork unless union labor was used in the process of slaughtering the pig. And at the same time, a Texas legislature could pass a law prohibiting the sale of pork if union labor was used to slaughter the pig. And there could be a spillover to abortion rights, gun rights, and other topics less divisive than how pigs are housed. I expect the Supreme Court will overturn Proposition 12. It'll be interesting to see what the court does.
Yeah, that would. Yeah, I have to say my gut reaction is that that would be an instance where I would like to see the dormant Commerce Clause power used. That would be a mess. That scenario you were painting would just create a federalist mess.
Yeah. On both sides. It's just crazy. All right. Number 2 on my list. It's not a case so much as it is a story about a defamation trial in Virginia and the explosion of law tubers. It's the case, of course, of Johnny Depp and Amber Heard. And for a few months, everybody wanted to talk about topics such as actual malice, public figures, and reckless disregard of the truth. Normally, when I tell people at cocktail parties about the importance of requiring actual malice in a public figure defamation case, I'm usually met with blank stares. Occasionally people fall asleep. But this past year, everyone had an opinion and wanted to discuss Johnny Depp and Amber Heard. I have not seen this level of coverage and widespread interest since the O.J. Simpson trial. The case launched a new subspecies of social influencers known as law tubers, lawyers who sit on YouTube and explain the law on YouTube and other social media. And I imagine this is an area of social media that will only grow over time.
Yep.
All right. Number 1 on my list. I know we try to stay away from politics and substance here on the show. We're mostly about procedure, but number 1 on my list has to be the Dobbs case. We're not going to get into the nitty-gritty of the merits of the decision here or how it may have impacted the midterm elections, but the big story was the leak of the Dobbs decision. Who did it and why, still unknown. How the Supreme Court reacted, how they investigated its own clerks, how the leak came to further erode trust in the high court as an institution. The impact of Dobbs inside and outside the judicial system will be felt for years to come. For me, it's the number 1 biggest legal story of the year.
Yeah. It'll be interesting to get one of those tell-all books by some insider in the court.
Yeah.
Well, okay. We'll circle back here to a couple more stories that we covered on the podcast in 2022. These are a couple of cases or topics that I put under the subject of Tim's hobby horses. So one of my hobby horses, or my soapboxes I like to get on, is about the no citation rule and non-published decisions generally. We elevated this to a full episode in episode 22 when we brought on guests David Ettinger and Dean Bachner from the Horvitz and Levy firm. And I used the insight that they offered in their article about Rule 8.1115 in writing a request for publication in the Doe versus Software One opinion that we talked about earlier, the case in which MSJ evidentiary rulings are deemed still to be discretionary. And it was originally a non-published case, but I took the insight that David and Dean made in their article from earlier this year that pointed out that under Rule 1115, litigants are not allowed to cite non-published cases for any reason, including in petitions for review. And even though that's an accepted practice, it's still against the text of the statute. So I pointed that out in my request for publication, that someone might like to raise your nice summation of the cases post Reed versus Google, but we wouldn't be able to under consistent with Rule 8.1115, and that request was granted. So my other hobby horse is about the rule of jurisdiction concerning notices of appeal, what types of orders are appealable, and the timeline to appeal. I wrote up a recent California Supreme Court decision and Court of Appeal cases that had forgiven untimely appeals. This was in re AR. This was a 2021 case, and in re BP, a January 2022 case, and in 2021, the Supreme Court had issued a surprising opinion. The court had held that an untimely appeal is not an absolute bar to appellate jurisdiction, at least in juvenile dependency cases. And the reason this seemed surprising to me was that until that point, a uniformity of California cases had held that an untimely appeal was an absolute bar to appellate jurisdiction. But in the court found, I think in that case, the ineffective assistance of counsel provided a loophole to excuse the untimely appeal in that case. We also talked about in episode 42 the Reed versus Aviva USA Corp case. An order granting summary judgment, although not normally appealable, was held appealable in that case. So that's just one of those cases that we talk about, Jeff, that it's not for nothing that that otherwise non-appealable cases are orders are sometimes deemed appealable, because as an appellate attorney, when you look at this at a non-appealable ruling, you tell the client, no, sit tight, don't appeal it. You can't appeal it, so just wait until the final judgment. But certain kinds of rulings, you have to put an asterisk next to it that, well, don't appeal it yet, but when you get to day 57, 58, 59, and if there still hasn't been a judgment entered, give me a call. Maybe we'll have to take up a precautionary appeal anyway and see if the court wants to deem it appealable.
Right.
Let's see. And then we talked about that cynics have suggested that the jurisdictional deadline to file an appeal is, quote, only as jurisdictional as the courts want it to be. That comes straight out of a Supreme Court dissenting opinion in Hollister Convalescent Hospital versus Rico. The court recently acknowledged that this supposedly ironclad rule is in fact riddled with exceptions. And the Garg versus Garg opinion from September 2022 involved problems related to electronic filing. So if you have a problem filing a notice of appeal timely because of some snafu with the electronic filing system, you may be able to get your neck out of that noose. So if you attempt to timely e-file a notice of appeal, but something goes wrong, here's what you do under the Garg decision. First, you file the notice of appeal as soon as possible, as soon thereafter as practicable, as the Supreme Court puts it. And at the same time, second, file a motion in the Court of Appeal explaining what happened and showing good cause why the notice of appeal should be deemed filed as of the date of your timely attempt. But don't wait 29 days is how long I think the appellant waited in the Garg case. And the court held that was not as soon as practicable. So your appeal is still untimely. But that's an important case to bookmark in case everyone files these things by e-filing these days. And every now and then something goes wrong. All right, Jeff, that concludes my list. We've got some other topics we wanted to talk about. We amassed a lot of great legal writing and oral argument tips and other types of tip that we decided we're going to aggregate and put into a standalone episode. We had some guests like Myron Moskovitz, we had MC Sangaila, we had Ross Guberman, we had Ryan McCarl, just a lot of great legal and general advocacy tips that I thought we would comprise into a single episode. Okay, and then should we do? I'm gonna go ahead and close with my vote for the top case of 2022, and maybe this I factor in the soap opera value and also the fact that Jeff, you and I kind of got a scoop in this case, but this is the Victory Bell case. This was the case that involves the law firm social media cautionary tale. This was the case in which successful counsel had bragged about their defense in a medical malpractice case and described the case as involving a guy that was probably negligently killed, but we kind of made it look like other people did it. And back at their law firm, they have a victory bell, and they rang the victory bell while making that announcement. Someone improvidently put that video clip and quote on the law firm's website. Took it down promptly thereafter, but not soon enough for social media to make it viral. We were pleased to invite the attorney who wrote the successful motion for new trial in that case. Brooke Bove explained why her motion was successful. And it gives an inside scoop, because a lot of commentators, Jeff, if you recall, were talking about, oh, that ought to, that's the judgment ought to be vacated, and a lot of attorneys, especially good appellate attorneys, would say that happened outside. It's not a court irregularity. I don't see any grounds for a new trial, and I was among them. I didn't see any reason for a new trial, but after speaking with Brooke Bove, I understand it now. So take a listen to episode 57.
Well, it's got my vote as the top get for our podcast of interesting cases of people involved in cases on our podcast.
That's right. All right. Well, I think this is going to be our next to last episode of 2022. We want to wish everyone a Merry Christmas, Happy Hanukkah, Happy Holidays, Happy Festivus, whatever, however you celebrate. We hope you do it in style this year.
And before we let our audience go, I've got a Christmas edition legal tidbit that will warm your heart about the industry we all have chosen to work in. This story comes out of North Dakota. It's about a law firm that decided to sue two former associates for a refund of their salary for not making their billable hours. Again, this happened in North Dakota. These associates had a contract with a clawback provision, and if you don't make your billable hour requirements, the firm's going to claw back the salary. And some interesting facts about this case: the firm received $800,000 in PPP loans. The firm sent a bill to these former associates. The bill wasn't paid. Lawsuits were filed against these two associates, and summary judgment motions were granted against these two associates. And the cases are up on appeal in North Dakota. So my Christmas message to all of you in our audience is, thank God we're not partners at or associates at that law firm.
That's right.
Bah humbug.
That's right. All right.
With that, we want to thank our sponsor, Casetext, for sponsoring the podcast. Each week we include links to the cases we discuss using Casetext, and listeners of our podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
And we want to thank those of our listeners who have already reached out to us with some excellent suggestions for future episodes. If you have a suggestion for another guest or topic for a future episode that we should cover, please email us at info@calpodcast.com. Or if you have either Jeff's or my email addresses, feel free to email us directly. And in our upcoming episodes in 2023, as always, be sure to look for more tips on how to lay the groundwork for an appeal when preparing for trial.
See you next time, and bah humbug.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.